Okay. Well, thank you everybody for spending time on a beautiful and rare sunny day here in the Minnesota, Rochester, Minneapolis, St. Paul, everybody. Mr. Vogel, could you please move forward? We're going to call the meeting to order and have you do a formal roll call, please.
Certainly, Mr. Chair. Senator Champion. Senator Champion. Ms. Dawson.
Present.
Thank you. Mr. Esme.
Present.
Ms. Evans.
Present.
Mr. Gaffin.
Here.
Mr. Hanson.
Present.
Ms. Huntley.
Present.
Mr. Irvin.
Present.
Ms. Kaser.
Present.
Mr. Kammer.
Present.
Lieutenant Knotts. Lieutenant Knotts. Judge Gulick. Judge Gulick. Senator Matthews. Senator Matthews. Ms. Mattson.
Present.
Thank you. Representative Mueller.
Present.
Thank you. Inspector General Modi.
Present.
Mr. Page.
Present.
Ms. Robertus.
Present.
Representative Robbins. Representative Robbins. Mr. Sandoval.
Yes, sir, here.
Thank you. Judge Satterback.
Present.
Judge oh, thank you, Judge. Ms. Sherlock. Ms. Sherlock. Mr. Tatum. Mr. Tatum. Ms. Williamson. Ms. Williamson.
Present.
Oh, thank you, Ms. Williamson. And yeah, thanks for letting me know. All right, Mr. Chair, 17 of the 24 members are present. A quorum is present.
Yeah, thank you so much, Mr. Vogel. And again, thanks everybody for being here. Going to note that a copy of the April 22nd Task Force meeting minutes has been posted to the Task Force website. And I open it up now to anybody having any corrections, amendments, comments at all regarding those meeting minutes. Okay, with no objections, I'm going to declare that those meeting minutes are approved as distributed. Moving forward, we got a lot today. I think it's going to be a great meeting, and I'm excited to move forward on. We're going to update on a lot of the subcommittee's actions. We are going to discuss adding some structure to analysis of data, and but before we move forward with that, I have asked Mr. Vogel to do some comment on the per diem policy, specifically as part of the legislative task force. Individuals that and Mr. Vogel will identify who those are, can seek per diem reimbursement for their work. And just to be candid, there have not been many people doing this. And I want to just ensure that people understand that policy, and if they are eligible and need that per diem, they should certainly feel free to pursue it. Mr. Vogel.
Thank you, Mr. Chair. And I'm actually going to take this opportunity to work in a reminder also about the means for public comment that we have here on the task force website. So you should be able to see the front page of the task force website here, lcc.mn.gov/HSBTF. And at the bottom of this front page here, we have this button here to submit public comments for the task force. I'd like to thank members of the public who have submitted comments so far. The task force members, you all should have access to those. Please get in touch with me if you haven't been able to. And there's some powerful stories there. So you are being heard, and I would urge members of the public listening who have stories to submit them. So moving on to another place on the website, then for the members' purposes, I'm going to this meetings tab, task force meetings here. At the bottom, way in these early meetings, we were posting copies of this request for reimbursement form. So just as a reminder to the public members, that is to say, if you're not employed by slash the government. You're entitled to claim a per diem for this work that you're doing. You're doing the members of the public a service, and so you're entitled to the $55 a day per diem for example, attending this meeting today. If we were not meeting remotely, there'd also be potential reimbursement for mileage and other expenses that you incurred for this work. But since we're remote, that's kind of like not enormously relevant right now. But if you do want to claim a per diem, again, you can just go to the website, find this form at the bottom of the meetings tab, or just shoot me an email and I'll send you a copy. And it's actually pretty simple. I'm just going to do a mock form for myself here. I am not claiming a per diem. I work for the government. So, but you just put the date here, description of activity. You just put remote, Zoom, something like that for place of meeting. You'll want to check that you're claiming a per diem. Again, there's the potential for reimbursement if, for example, you had to drive somewhere or lodge somewhere. But again, I don't see that being relevant for our remote work. You'd want to sign this then. And then please send a copy of this form. You can just email it to Chair Geffen and myself, and Chair Geffen would then approve your request, and I can then send that over to the LCC finance people, and we can get that processed for you. So it's a pretty simple process, and I would urge you to take compensation that you're entitled to. I do want to note, so as a caveat, I'm not a tax guy. This is not tax advice. The per diems count for tax purposes, as I understand it, as you being a contractor for the state. So that would be taxable income. And if you earn more than $600, I want to say, per year, you'll be issued a Form 1099 miss, I believe. You'll be issued a tax form. So just be aware of that for tax purposes. If in the, I think, unlikely event that you claimed reimbursement, so for example, that mileage, lodging, that sort of thing, that wouldn't be regarded as taxable income from what I understand. Again, take that with a grain of salt, not a tax guy, but I do have some memos that I could share with you if you're interested in exploring that further. Just wanted to make sure that, I had that out there. And so, yeah, I'm happy to answer any questions you have now or, after this meeting. And I'm happy to work with you if, you want to, say, figure out when you've been meeting, that sort of thing. So thank you.
Mr. Vogel, one of the questions I had, and someone had asked me this, and I'm not trying to put you on the spot. If you don't know the answer, we can certainly update people. How far back could you go? Like if someone had not been submitting per diem requests, could you go back to December, or are you limited in that?
Mr. Chair, I think that's a question I definitely would want a definitive answer to, and I don't have one right now. So I'll check into that and send out a general email with the answer to that.
I appreciate that. Thank you so much. Does anybody else have any questions about the per diem protocol process? Anything else for Mr. Vogel?
Thank you, Will, for sharing all that. Good job.
Thank you so much, Mr. Sandoval, and thank you for your time as always. All right, moving forward, we're going to stay with Mr. Vogel. Mr. Vogel has been working on some putting together some analysis of data sets that have been coming in. And since many of us are kind of visual learners, I think it's a great way to do it. And the other thing I thought Mr. Vogel talked about that was so important is we have to remember that our obligations to the community as a whole, that people are watching, and we want to make sure that we're getting data back to our community members in a way that's digestible. So I think it's a great time to start moving forward with maybe some more charts and maybe more USA Today than New York Times sometimes. So, Mr. Vogel, thanks so much again, please.
Thank you, Mr. Chair. And actually, I'm going to start with the New York Times part. Just sort of as a high-level overview, I just kind of like to step back and sort of show you where all this is coming from. I'm about to show you some charts and basically, where am I getting that? So we've received 4 data sets so far from the Department of Human Services, and they represent a lot of work on the part of their data team, for which I'm appreciative, and I'm sure a lot of you are as well. And it represents a lot of work on the part of the data subcommittee to work with DHS to get this get these data sets. So just to sort of like briefly go over what these data sets entail. Data set 1 essentially looks at a high level at the background study process. So it gives us numbers of cases that were studied, determinations, disqualifications, that sort of thing, broken down by race, by gender, and then it sort of hones in and gives us those sort of breakdowns for specific programs that the Department of Human Services and other departments do background licensure for, or rather the Department of Human Services does the licensure, but you know what I mean. The second data set essentially, sorry, blanking on it. The second data set then essentially looks at the risk of harm determination. Sorry, there I go. That went into the disqualifications in particular that we saw indicated in the first data set. So risk of harm is something that the department needs to determine as part of the background study process under 245C17. And so here again, we have this sort of honing in from general to specific with the statistics there. Now, I'm sort of glossing over those two because data set 3 is the one that I've mainly been working with whenever you've like seen me present a chart or something. That's really honing in on sort of the meat of the disqualification determination, like where that came from. And by that, I mean, I guess I'd like to highlight most of all, table 3, which breaks down where what evidentiary standards led to, what evidentiary standard to determine that a crime or conduct took place led to that crime or conduct leading to a disqualification, if that makes sense. Sorry, this is being very New York Times, not USA Today. And then table 6, which I've worked with a lot. That's where a lot of the stuff that you've seen from me came from. Essentially breaks down the crimes or conduct and by evidentiary standard that led to disqualification determinations. And just as a heads up, after I get done like talking about a lot of numbers, the charts I'm going to show are based on table 3 here, specifically the adjudication of delinquency. And finally, data set 4, it essentially, what do I want to say about that? Data set 4 looks at the reconsideration process. Basically, it's something. It's a data set that I look forward to hearing more discussion about and analysis of. To be honest, we have this data, for example, on what happened, on how many people request reconsideration versus those who don't. Again, broken down by race and gender. We have data on what happens to cases where somebody has requested reconsideration, that sort of thing. And again, sort of moving from the general to the more specific with these specific programs. So that's just sort of an overview of where all this is coming from. And if any of you are interested in looking into any of these, I know you have it in your inbox somewhere, but just shoot me an email. I have these at the tip of my fingers and I can just resend it to you. What I do essentially is use these PDFs to create those spreadsheets that I've sent out. And again, I can send those to you just because spreadsheets are easier to work with. And then analyzing those spreadsheets in turn, allows me to make charts like these. So are you still seeing my PDFs or can you see my my PowerPoint right now?
I think it's still the PDF.
Okay, yep, I messed up my screen sharing. Just a moment. Juggling a lot of things to share right now. All right, so that's all a long-winded way of introducing I looked at table 3 from the third data set, which is again breaking down the evidentiary standards that were used by the department to make the determination that somebody had done something that was on the list of disqualifying crimes or conduct. And specifically, I was looking at the adjudication of delinquency evidentiary standard. So, caveat that I am not a lawyer. My understanding is that essentially represents the juvenile court system. It's you committed an act as a juvenile and the juvenile court system found that you did it. That's an adjudication of delinquency. Please, if I'm off base there, just let me know. But so this is, the disqualification subcommittee is looking at the issue of the use of juvenile records for disqualification purposes. So this seems like relevant information for that. So we have the data sets for 2018 and 2019. For 2018, adjudication of delinquency represented about 6% of disqualification determinations made that year. Convictions were the vast majority. But I should note 6% is, you can see it as a small number, or you can see it as more than 700 individuals. So honing in on that 726 726 cases of disqualifications based on a adjudicated delinquent record. There we go. Those disqualifications led to essentially this breakdown of disqualification periods. So 91 people, for example, received a permanent bar based on an adjudication of delinquency. Then we see 25% or 183 people got a 15-year disqualification. 10-year, 7-year, et cetera. I'll note this year's disqualifying not entered for offense is sort of an artifact of the DHS data system, from what I understand. Like, that's not its own category. These numbers should be in these other categories. We just don't know which one. But then we have this breakdown of what the disqualification periods were. We also have a breakdown of the race of the people disqualified. And here, I guess just as a surface level reaction, I'd like to point out that we see a plurality of these disqualifications for essentially what somebody did as a kid. Plurality of those in 2018 were of African Americans. Now, we've had these discussions about the department being, essentially downstream from the criminal justice system. So I'd just like to throw that out there. But, just looking at this chart, my initial reaction is this is quite a disparity here of outcome, if nothing else. And again, I just as a reminder, the adjudication of delinquency, this is what somebody did when they were a kid. 2019, we see pretty similar trends. Again, about 6%, the total numbers of disqualifications that year went up. The total numbers of adjudicated delinquents that year went up. But as a result of those two, we still get about 6%, which again, that's small or that's big, depending on your perspective. Of those 6%, or about 1,100 some, we again see about 12% received a permanent bar. In this case, about a third received a 15-year disqualification. About a third received a 7-year disqualification. And this chart, in a sense, is more accurate than the one for 2018 because we have a much smaller years disqualifying not entered for offense. But then looking at the racial breakdown again, the plurality of these disqualifications were of African Americans. I'd also note in both these cases, there was a little bit of discussion in the disqualification subcommittee of the Native American category, which again, small or big. 7% of disqualifications in both years were for an adjudication of delinquency were for individuals who fit the Native American category in the data, which the census, the 2020 census, as I recall, had about 1% of Minnesota's population being quote American Indian or Pacific Islander alone, if I'm remembering that correctly. It's a little apples to oranges. The data set we're getting is based on the FBI's crime statistics categories of race, which isn't quite the same as the census. But just as a gut check here, again, I think this represents a disproportionate disparity of outcome for Native Americans as well as African Americans. So that's sort of what I've got, just as a very surface level reaction to this data. Obviously, a deeper analysis, what this means and what this implies for your work is up to you all. But that's sort of what I've got. I'd be happy to answer any questions or share any of these as you have your discussion. Thank you, Mr. Chair and members.
Thank you so much, Mr. Vogel. Any questions for the data Mr. Vogel presented? Or I can't see everybody, but if somebody's got a hand up, let me know. I think what we know, and it'll lead, I think, into our next discussion, is data analysis is difficult. I think a lot of the people in this group have expertise, anecdotal information, lived experience in the realities of the Background Study Act. A lot of us don't have expertise in data analysis. Some of us do. And with that, what we've sort of noticed is with the current data subcommittee that was tasked originally with gathering data, putting together lists of data that would support changing things, leaving in the same, understanding why a certain thing is important or unimportant, has had to morph into something it isn't. And the current data subcommittee has wonderful people on it, but also we need more data analysis. So the chairs of the subcommittees, and I've met with some of you personally, we've come up with an idea to create another subcommittee to some degree, to a great degree, a data analysis subcommittee that will be set with individuals with time, expertise, quite honestly, the ability to do the data analysis that a lot of us find difficult, and I'll raise my hand on that one. I'm definitely more USA Today on that. And so, and doing it in a way, that work is, for some of us, grueling. It's going to be a little bit longer. The meetings, although obviously will be public, will be working meetings, laptops open, crunching data, tasked with very specific data analysis points. Each of the, and so that's our idea moving forward. I think the proposal on this is to make sure that it's the right group. We're going to create the group, and then we're going to have independent conversations with people to determine who's got time, ability, expertise to weigh in. And so Ms. Evans, and I mean, Vice Chair Evans has been very involved in this. Ms. Evans, is that an accurate kind of portrayal of sort of where we're at with this creation?
It is. It is.
Okay. Does anybody have any questions about that idea? I think we're gonna some point move towards a resolution on this, but the other thing that would happen is the data task force as it stands will stay together, but will continue to do its work towards gathering data, but not this really in-depth analysis. Mr. Sandoval, please.
Yeah, I was just gonna motion for a resolution. No question.
Okay, and maybe we can, let's leave it open for questions for a minute, and then we can do that formally. Does anybody have a question about us moving forward with this sort of data crunching crew? Okay. And Mr. Sandoval, do you have a specific, any specific language moving forward with this motion?
Just a motion for just a data analysis committee, to start digging in and yeah.
And with that motion, authorize both the chair and vice chair to select the individuals to be members of that next subcommittee. And our idea was not opening it up to everybody, not to exclude, but just to get the right people together and just get down to business. Is that?
Yeah, exactly. For those who actually have the time and the ability, being on a few committees myself as it is, it's hard to, have that capacity. So for
Agreed.
folks who can make it.
I second.
And Mr. Vogel, is that an, just hold our hands through whether or not we properly did that, and if it's been made clear before the task force and seconded.
It seems proper to me and it seems clear enough to me, but I am going to read what I understand the text of the motion to be, just to make sure the members.
Why don't we do
find it
that? I
clear.
think that makes a lot of sense. Please do.
Yeah. So as I understand it, Mr. Sandoval's motion is to establish a data analysis subcommittee and to empower the chair and vice chair to appoint its membership. Does that comport with what you understand, Mr. Chair, and with what you understand, members?
Yeah.
All right. In that case, that motion was made and seconded, Mr. Chair.
Can we put it now before, well, I guess first, any questions regarding that before we vote? Okay, Mr. Vogel, seeing no hands raised, can you please do a formal vote?
Certainly, Mr. Chair. Senator Champion. Senator Champion. Ms. Dawson.
In favor.
Mr. Esme.
In favor.
Ms. Evans.
In favor.
Mr. Gaffin.
In favor.
Mr. Hanson.
In favor.
Ms. Huntley.
In favor.
Mr. Urban.
In favor.
Ms. Kaser.
In favor.
Mr. Cameron.
In favor.
Lieutenant Knotts. Lieutenant Knotts. Judge Kulik. Judge Kulik. Senator Matthews. Senator Matthews. Ms. Mattson.
In favor.
Representative Mueller.
In favor.
Inspector General Modi.
I vote aye.
Thank you. Mr. Page.
I vote in favor.
Ms. Robertus.
In favor.
Representative Robbins. Representative Robbins. Mr. Sandoval.
Yes.
Voting for your own resolution. Judge Satterback.
In favor.
Ms. Sherlock. Ms. Sherlock. Mr. Tatum. Mr. Tatum. Ms. Williamson. Ms. Williamson.
In favor.
Oh, thank you, Ms. Williamson. Sorry to put you on the spot like that. All right, Mr. Chair, we have 17 ayes and no nays. The motion carries.
Thank you. And we'll be doing some preliminary work on getting this new subcommittee together quickly. We'll be informing all members in the community regarding that. And hopefully even by 2 weeks time, we'll have some preliminary report back from that group. Again, it'll be pretty, not giving them a ton of time, but I think we just have to get down to crunching these numbers. So thank you all. I think it's a good step moving forward and will help us sort of process some of this data more meaningfully. Moving forward, we're going to go and just have some discussions now, updates from our subcommittees on the work that they're doing. Obviously, we want to ensure that the greater task force knows what the subcommittees are doing and has opportunity to weigh in positively, negatively, critically. It's important that you're involved in the activities of the subcommittee, even if you're not on the subcommittee. So, Mr. Vogel, I think the DQ subcommittee is going to go first, and I guess that's me. This is going to be, without a doubt, the lamest PowerPoint in the history of the world, but I'm visual, and so here it is. We're just talking about some of the things that the juvenile subcommittee or the disqualification subcommittee has been discussing, specifically as it relates to juvenile matters. And this will be kind of in line with what Mr. Vogel talked a little bit about during his presentation. Some of the slides will even just duplicate. If we could just go to the first slide, Mr. Vogel. So again, I focused just on 1 year of the data. I didn't go through both. I focused on the 2019 data. And what we know is individuals that are adjudicated delinquent and not permitted or disqualified, it's over 1,000 individuals. And again, I thought, as Mr. Vogel identified, you talk about 6%, but we are talking about 1,100 individuals, let's say a year, that are disqualified from oftentimes employment. And these are individuals then, and this is anecdotally, that don't come back. So, they're not going to come back the next year oftentimes and reapply. They may never, try to work in any kind of DHS, MDH kind of licensed entities after this. So although you can look at the 6% and say small, I still think it's a significant number to look at. Those are a lot of people that could help other people, in my experience, and sometimes those might be, people that employers could use. Some of these individuals probably shouldn't be working with vulnerable individuals, and we'll kind of get to that. But we are dealing with over 1,000 people. Next slide, Mr. Vogel, if you could. And then, again, this talks about more for, these are some significant amount of disqualifications. I mean, even the 7-year disqualification is significant, and that's at 365. But the whole rest, the permanent, the 15-year, and the other 68% have a minimum of a 10-year disqualification. So again, I think we're seeing significant numbers that these actions of juveniles are leading to really significant long-term impacts. Mr. Vogel, next slide, please. And I guess this was the one that was so, I don't want to say surprising, because I think it is rather consistent with criminal justice numbers. But we see that, in a state where I believe the census had the African-American population at about 12%, 46% of individuals who are disqualified based on adjudications of delinquency are African-American, and the 1% of Native American is at 7%. I concur with Mr. Vogel's analysis that it might not be apples to apples, but it's perpetuating and showing that the disproportionate impact these laws have on individuals of color. So thank you on that slide. And that sort of guides us to some degree as we were talking and looking at this as part of the disqualification, that those are significant disparities that we want to understand, address, and think about. If you could move to the next slide, Mr. Vogel. So this was presented in our last meeting, but I just thought we would sort of give a refresher. The disqualification subcommittee had been brainstorming some ideas what to do with juvenile records, with the belief that based on brain science and based on that a lot of these records are committed by younger individuals who might not pose a risk of harm. Here were some of the ideas that were originally thought up. Prohibit disqualifications on juvenile records after supervision ends. Prohibit disqualifications based on juvenile records for offenses when the individual was under the age of 14. Only use convictions of individuals who are tried as an adult, and those that are extended juvenile jurisdiction, the EJJ cases. So the non-serious, well, I shouldn't say the non-serious, but the cases that stay specifically within the juvenile court and that aren't part of the EJJ extension wouldn't be disqualifying incidents. There was a discussion on the look back period, and there was also a discussion to permit DHS to set aside permanent disqualifications if the disqualification was based on a juvenile record. If you go to the next slide. We also came up with a new idea, and the suggestion is that if a person, a juvenile, has a case that remained within the juvenile court, so again, it wouldn't be those cases that were where individuals were tried as an adult. Those are going to be criminal matters. And it would also exclude those juvenile cases that go through the extended juvenile jurisdiction. So again, these are cases where the individual is a juvenile, tried as a juvenile, and it stayed within just the regular juvenile court system, that those cases, regardless of what the offense was, would that individual be disqualified for only 5 years. So it's a 5-year disqualification for juvenile only cases. And why do we do that? Well, let's go to the next slide. This is the world's worst PowerPoint slide. Why 5 years? And I guess we came up with that's consistent with the Adam Walsh Act. And, Adam Walsh actually talks about convictions, and a juvenile adjudications of delinquency are per statute, not convictions. But that's why we came up with the 5-year. We didn't come up with a consensus really on anything, but we certainly don't have consensus of whether that 5 years begins at the incident date, at the adjudication date, or at the release from court supervision date. But we are at this point looking at the 5 years. You can go to the next slide, Mr. Vogel. We believe that this idea, and again, we don't have consensus on all of this, but its idea is that it's consistent with safety. And that, so if a juvenile reoffends during that 5-year period, the individual is going to be disqualified based on those subsequent actions and mistakes. So if the juvenile does not reoffend, well, it would reflect, and I think would show, that this individual has matured, is no longer making decisions that bring him or they back into the juvenile court system, or if they're 18 into our criminal court system, which is also consistent with brain science, that as children advance, grow up, their brain changes, they start making fewer bad decisions, they become less impulsive, and those traits are more consistent with somebody who wouldn't pose a risk of harm to our vulnerable population. We did come up with just a real brief example. If we could go to the next slide, Mr. Vogel. And it's just, so 2013, a 15-year-old juvenile adjudicated delinquent for attempted burglary at a closed convenience store, completes the terms of his court obligation January of 2015. When he's 17 years old, he has no subsequent problems with the law, applies for job as a PCA in January 22. He's not disqualified, as his disqualification ended in January of 2025, years after his release from supervision. Actually, in this example, I would note that the focus, it was on the release from court supervision as the timeline for the look back period. It might not ultimately be that, but that was how this example was written. And that's a little bit of an overview of what we've been doing regarding our brainstorming of juveniles within our disqualification statutory scheme. And that's really all I have, but I want to open up questions about this example, this idea, and just if there are things that you believe that the disqualification subcommittee should be looking at regarding juveniles, because right now we've just been focusing on juveniles. Anybody have thoughts about it? Mr. Esme, please.
So just to, that would have been a 15-year disqualification in the example for the burglary. So assuming the 15-year-old was maybe on probation, even for just a year, then under the current statutory scheme, that disqualification period would run until the individual was 31 years old, if I got my math right.
I hope your math's right, because I can't correct it, but yeah, I agree. It would have been a 15-year disqualification. And so you're reducing the disqualification again with a period of no subsequent offenses. Yeah. That's good. That's actually really helpful clarification. Thanks, Josh.
And then I guess I'd build on that to say, I like the idea, first of all. And, if we start to think about what the advantages are to that, one is it would reduce workload for DHS for that period between when the individual, it would now pass at 22 and 31. How it would work right now is the individual would get disqualified, but then would have the set-aside opportunity if they follow through on the set-aside opportunity, which is something that, we've already discussed about how much kind of fall off there is on that, but then they follow through with the set-aside opportunity. DHS may go through an analysis and may actually be right now pretty permissive with their set-aside decision, given that it's it was an act committed by a 15-year-old, and say they're, it's 10 years later, they're 25, they've got a clean record since then. In my, limited and anecdotal experience, I think I would look at that case and be like, this is one where we've got a good chance to get a set-aside. But, that creates a lot of work for, for the department, for the individual. And then, so that's one advantage. Another advantage then is we also head off the opportunity that somebody finds out that they're disqualified, and then that's the last they think of it, and they consider it, a door closed, that they don't pursue any further. So just wanted to kind of think through that stuff and make the record clear on the benefits that I see from the proposal.
Yeah, I agree, Mr. Esme. And I think on both sides of that, the DHS side too is, I mean, if you think about, with each new job, each new background city, each new disqualification, each new request for set aside, there's a lot of work there, even if the person is ultimately set aside. It's a lot of work and time. People lose jobs during that time. Great point. Vice Chair Evans, please.
Nicole had her hand up first.
For some reason, I don't see that.
That's okay. She did though.
Thanks. Thanks,
Nicole,
Gina.
please. I didn't. I apologize.
No worries. It's Minnesota nice. I love it. Anyway, a couple of things. I'm wondering if we can receive the world's worst PowerPoint, because I didn't think it was that bad. So wondering if that can be shared with us.
Yes, that makes me very happy. I just sent it like 10 minutes ago. That's why it's so
Okay,
bad.
sweet. And then secondly, does this, when we're looking at these kind of suggestions, might it help our case to look at other states that use a similar standard to say, this is being used here with effectiveness, and I don't know where those states are or if they are, but I guess I pose that both as a question and then maybe food for thought going forward.
Yeah, and I think it's hard because really we look at so many states. We've done some state by state analysis, and maybe as we come closer to getting real suggestions together, we can look back. I don't know if we're gonna get the data on whether it's working or not, because I think that's a hard data set. I mean, is our state's DQ laws working?
Right.
I don't. I think it's a hard answer, but it's a really good point. One of the hard parts too is a lot of states don't use juvenile data. Adam Walczak doesn't use juvenile data as we understand it. So some areas are going to be easy, some are not. Like same with the preponderance of evidence. It's hard to do a bunch of searching because no one really does it. But
I just think it could be
yeah.
compelling for legislators in making a decision to say, these are some other, so that they understand that there are, similar, or I understand it's not going to be apples to apples, but I just think that it could be helpful in it for a legislator when they're trying to make a decision. Is this the right thing to do?
It's really a good point. Like they tell you in law school, and we teach in law school, make sure the judge feels that he or she, they're not doing something that's never been done before, that this is within the realm of what has been done before. So this isn't absurd or crazy. So I think it's a really good point, and something I think we'll add to our or our disqualification subcommittee on that issue, is to try to figure out that juvenile piece more. So thank you so much. That's a great comment. Vice Chair Evans.
Yep, now it's my turn. Thanks, John. And I just want to be super clear. I just presented this information to our March Government Affairs Committee, and I just want to be really clear about the disparities. According to the census data from 2021, Minnesota's population is 83.8% white, 7% Black, and then 2 or more is 2.6. And so when we're talking about disparities for Black and brown bodies, I just want to make sure that we're sharing that information accurately, because the disparities are really, really bad.
Thank you so much, Vice Chair Evans. And I think I'm really glad you corrected me and us, and all. I thank you so much. Mr. Sandoval, please.
Yeah, so I didn't think your slideshow was that bad. Actually. I thought it was you did a great job. So and as I'm kind of just hearing it, and it's kind of resonating with me, on a personal level, being part of this committee and being someone that has the personal experience of having permanent bars. Like I can't imagine, being a juvenile and like never getting that opportunity. Like as an adult, that's pretty hard on me. Just as an example, about 10 years ago, I was 24 and I had this awesome job, I was actually speaking in high schools and middle schools and leading presentations. I led over 600 presentations, sharing my story and encouraging youth that, to think about their choices, right? And, sharing my story in that and just kind of trying to have that impact. And because of my background, I was not able to continue in doing that. And it was super discouraging for me as a young adult. And, I'm thankful that, it's kind of in my nature not to give up and to, just be bold and see what else I could be doing with my gifts. But, I just think about like, what about those that aren't as bold and, that just are permanently disbarred from, permanently. And so, I just know how it was for me as a young adult, and I can't imagine, how that would be as a juvenile and not even to have an opportunity, so.
Well, thank you. And thank you for not giving up. Our world's better for it. So thank you. Does anybody else, before we move on to the remedies subcommittee, does anybody else have anything they want to add or discuss regarding the work of the disqualification subcommittee? Okay. Thank you. And with that, why don't we move to remedies? And Ms. Dawson, are you presenting for remedies?
Yes, however, I did not prepare a PowerPoint.
Oh, terrible.
Sorry, everybody. So just an update on the remedies subcommittee. We have really exclusively been focusing on the permanency list. We're not looking at the permanent bar yet, but the permanency list. And I believe we have one more meeting left on that, but where we really have is, and actually our notes are on the task force's website. So even though I don't have a PowerPoint, if anybody would like more detail as to what we have discussed, the notes from our last meeting, it's actually 4 pages of notes are there, and they're broken up into sections. So by all means, if you'd like more information, you can definitely look at that. And we've sort of highlighted what we've talked about, as well as tried to identify what we are still talking about and still considering. So that should be helpful from that document. So where we are so far is just sort of general discussions and potential recommendations that we're looking at. One is separating out really the use for these background studies so that to have different disqualifying crimes. And what I mean by that is we're talking about separating out background studies that are needed to comply with the Adam Walsh Act. Another one that we are also having to consider is there are background studies required for the Child Care Development Block Grant, the Children's Residential Facilities, and Head Start. And so those are they're essentially in their own consideration. Those are tied to federal funding. And so we're definitely keeping that in mind. The next, we call them buckets. The next bucket that we're looking at would be a different sort of disqualifying crimes list for the alcohol chemical dependency related field. The third would be what we're calling the family caretaker. And then that's the family PCAs, where we're really looking at a little bit different, that individual may already be in the home. And so if the person is already in the home and having that contact, should they be considered differently than just your stranger who's coming into the home? The last bucket then is vulnerable adult, just this other vulnerable adults. I understand the alcohol chemical dependency related are technically considered vulnerable adults, but we're separating out from nursing homes, long-term care facilities, non-family PCAs. And so one question that we have put for DHS that Ms. Kissane is getting back to us on is how often do programs have to go through multiple of these background studies? So for example, if someone is having to go through both the Adam Walsh and the Child Care Development Block Grant background study, because we would like to, if we're making recommendations, not make this extremely complicated and hard to follow and just duplicating efforts. So that's definitely something we're considering. Some other general recommendations is there a way to separate out people for background studies who have direct contact versus no direct contact? A third thing, and this is a little bit of dipping into the DQ's work, but really looking at, should juveniles be included in just the permanent list? We're not getting into the sort of that 15-year 10-7, but just simply, should juveniles be in that permanent DQ list? And the reason for that is definitely as we're looking at Adam Walsh, our group has done some state-by-state comparisons, and Minnesota does seem to be unique in our use of the juvenile records. That is not we do need to firm that up a little bit, as our state comparison was more in relation to the preponderance of the evidence standard, but that was just something that we noticed while we were doing that, which preponderance of the evidence is our next topic. And then just so that we're still tracking it, is there is still the permanent bar under, I believe it's 245C.24. That is something that our subcommittee it's on our radar, but that's part of our last topic, the actual bars to be discussed. So then, as far as looking at the specific crimes that are disqualified, our group has done a breakdown of that actual list under 245C, really comparing it to the Adam Walsh, as well as the block grant, the residential facilities, and the Head Start. And there are definitely quite a few that are still going to be barred in order to have that federal funding, but we have identified certain crimes that are currently on the permanent list that would not actually be required to be permanent or, quite frankly, disqualified at all. So just by way of example, under the Adam Walsh Act, which really actually only looks at felonies, I want to be very clear on that. The Adam Walsh Act has bars for felonies. It does not discuss gross misdemeanors or misdemeanors. So under the Adam Walsh, it is a 5-year bar for a felony offense, domestic assault, where the victim is not a spouse or child. Right now, our permanent DQ list does not separate out who the actual victim is. It also is a 5-year bar for a felony offense of either assault, 1st or 2nd degree, or 3rd or 4th degree, as well as drug-related offenses. So those are different. We have at least identified that current crimes that are on the permanent DQ list, which are not Adam Walsh offenses, would be criminal sexual conduct in the 5th degree, where it is a gross misdemeanor. Again, as the Adam Walsh really looks at felonies. The statute relating to criminal sexual predatory conduct, specifically where it's related to an assault crime, incest, violation of the predatory offender registration laws, great bodily harm by distribution of drugs, solicitation, inducement, and promotion of prostitution, felony level harassment or stalking, aiding and abetting, attempt or conspiracy, and then the other disqualifications that are based on judicial determinations other than a conviction. So your stays of adjudication, things like that. Disqualifications based on the preponderance of the evidence, and disqualifications based on juvenile delinquency adjudications. We do still, for our next meeting, kind of our main items for the agenda are really finalizing those 4 buckets that I talked about at the beginning. Our group is hoping to get those finalized, and then so that we can, of course, come back with formal recommendations, and then finalizing our recommendations for the permanent disqualification list. And so I apologize, everybody, I'm scanning my notes here. And so, yeah, and then, of course, looking at if we're making a recommendation that, for example, the chemical dependency related fields would have a different disqualification list, what that would actually be. And then we had one just sort of lingering question that the department, that DHS is also getting back to us on, and that is whether someone who formally had to register as a predatory offender but no longer has to register, is that person permanently disqualified? Because under the predatory registration, some individuals have to permanently register, some do not. And so I don't think that that was very clear based on the current statutory scheme work as to what qualifies. And so I think just the last point that to make is, as a group, we are looking, because we're considering the assault charges or assault offenses, because under the Adam Walsh, assault offenses would only be a 5-year bar. However, under I believe it's the child care block grant, and it may be the children's residential facilities, those are actually permanent bars. So that is something our group is having to consider of, do we keep it simple and just say any child-related contact, or do we try to separate it out depending on the actual background study that needs to be used? And that's where we're waiting for that information back from DHS on how often is somebody having to go through both of those background studies, such that it would just make sense to keep it as children in general versus trying to actually separate those out. And so we're just trying to get that answer. So that's the update.
Any questions for Ms. Dawson or the remedy subgroup? Okay, moving forward, thank you so much, Ms. Dawson.
Thank you.
Now we'd like to move forward to Chair Williamson. Can you discuss just an update on the data subcommittee? Chair Williamson, can you hear us?
Just one moment, Chair, please.
No problem. Well, is there, until Ms. Williamson's able to return, are there other members, Mr. Kamen, Mr. Burtis, that have anything?
Okay.
Oh, are we
My
back?
apologies.
Oh, that's okay.
My apologies, Chair. I'm so sorry, everyone. I'm gonna have a head cold going on here, so.
Oh, I'm with you. I understand. So
and right when
appreciate
you
you.
caught me, I really needed to blow my nose, so I apologize. Yes, with the wonderful overview that Mr. Vogel had given, as well as just concerns that have been expressed, I know I can say on behalf of the data subcommittee, and please remember, feel free. So I can just say that I'm very happy that Chair Geffen has offered a solution in regards to further analyzing the data sets that we've received as we shift more into that inferential type of data. I want to be very tactful and intentional about what is presented or what the outcomes are. Also, just wanted to just to state that we've been very happy to be working with DHS in regards to getting the requested data. We are in the process of, we submitted a formal request to DHS in regards to having someone from their data team to join one of our committee meetings, hopefully here in June, just to be able to get further explanation of the data sets that we've yet received. There's some other requests that have been submitted just in regards to the data that we've already received and just taking deeper dives. And again, want to just make mention to everyone, if there's other data that you think would be significant, please let us know so that we can get those formal requests in as soon as possible. And if anyone else from the data subcommittee has anything to share or add, please feel free to do so.
Okay, anybody else from data or anybody else from the task force in general have any questions for data? I mean, we've gotten lots of data from the data subcommittee, and I think as we start working through it, it's going to be, I think it's going to really reap some benefit. So thank you so much to the data subcommittee.
So John, I actually have 4 slides going over the information that Will started off with that are pretty good visuals if people want to see them. I think visuals always help.
Absolutely, please.
Okay. It's so funny, Will. I feel like you and I are always working on the same stuff. So here are the 4 data sets that Will went over to begin with. We got disqualifications by race, regulatory agency, and provider type. The second data set was disqualifications by race, risk of harm, the wrap back, and if Roy or somebody wants to just recap what that is, and provider type, and then crimes and conduct, and set asides and by outcome. And we're waiting for a follow-up on the set asides that will include the crime and conduct, which we didn't get the outcome by crime and conduct, which is going to be really important for us to have which set asides were granted and not granted based on crimes and conduct. So does somebody have the quick definition of wrap back for folks?
Mr. Chair, Ms. Evans, as I understand it, wrap backs are essentially you showed up in the BCA system because you got arrested for something or charged with something, that sort of thing. And this comes to DHS's attention. You may have potentially already have passed a background study and have the job, but if this comes to their attention, then they have to essentially reconsider you. Please correct me if I'm wrong on any of that. Well, anyone who knows, and especially anyone from the department.
And is that any time, right? Because they're constantly redoing background studies while you're working. Is that accurate?
As I understand it, yes, but that might be a better question for Ms. Kasane.
Or Kulani, I think, if who's on the call.
No, I'm here, but I'm not in a position right now to be able to give you a response, but I know it's some of the information that we provided, and I might be able to provide one shortly. If not, we'll get it to you after the meeting.
Okay. Roy, were you saying something?
I was just going to say the official definition we were given is that it's a notification DHS receives about new potentially disqualifying information for a background study subject with an active provider roster affiliation. And it says an eligible wrap-back determination means that the information received through the wrap-back process will be found to belong to the study subject. But after review, we determined to not be a disqualifying crime or conduct. So, yep, so you had it. That's the official, so.
And then this is just, again, we keep showing this, but this is that downstream thing that we are working on collateral consequences of the criminal legal system. And this is why I looked up that data for African Americans represent 37% of our population. And I think equally as like you look at American Native Americans at 9% and 5%, and they're like 1% of the population, 1.4% of the last census, which is just startling that it just never ends. And then this was just big for us that 2018, 2019, that substance crimes are making up almost 50% of 15-year disqualifications. It's almost all substance and property crimes is what we're talking about for 15 years of disqualifications, which I feel like is pretty substantial. That's what we're talking about, substance and property crimes. And so I think out of the data committee that to see that in a graphic is pretty big stuff. And then the one other thing that I thought was that we can be talking about when we're like fact finding and then making recommendations is this great graphic that Roy made for us is, when we're looking at low, these folks in blue are people who can continue to work. They do not pose a risk of harm and do not need continuous direct supervision while the reconsideration is being done. These 2,385 people. So the Department of Human Services has determined that they don't even need to be supervised while they're finishing up the reconsideration. And so why are we spending money on that? Why are we doing anything with those people? Just let them work. Like, as a taxpayer, that makes my pocketbook cry. Like, why are we doing that? And then these medium folks are people that need to be, need to be supervised while they're doing the reconsiderations. It'd be great to know how those ones end up. Like, that would be good data to know. How did these 3,258 people land? And what do we do there? And then the high folks are folks that need to be removed. And then I think these not applicable ones are probably the permanent ones or whatever. But I think this data set right here is important to us because this is how DHS determines the risk that someone poses while they're doing the reconsideration request. So those are just some of the data that I have been looking at and thought was important to report out to our March subcommittee on criminal justice reform. So, Josh.
Yeah, I just had a quick question, something I hadn't thought of before, but noticed while you were going through the slides. One of the slides before compared, had, this one here. Mm-hmm. That is a pretty significant increase in the number of total disqualifications between 2018 and 2019. Do we have any idea if that trend continued through the next couple of years, and if there is any explanation for that significant change?
Yep. So the explanation is because there were changes in child and foster care statutes.
So that's almost all child and foster care applications?
That's what they told us, right, Roy?
Well, isn't there a change in the law that required DHS to do some background studies they weren't doing before? Kulani, was that you? That was?
Yes. So
please weigh in.
Is, there were some disqualifications that, and this is all related to the enhanced childcare disqualifications, or the enhanced, let me try that again, the enhanced childcare background studies that we're required to do under the Block Grant. And we began rolling out that phase in those requirements at the end of 2018 into 2019. And so that was a significant change. And so some of the background studies were being handled at the counties. Those are transitioning over to the state. And so things were housed differently, numbers and information are differently. So we were doing a lot more studies. So a lot more people coming through the system on that. And then we were centralizing information as well. So that in both childcare and in foster care. So coming into compliance with Adam Walsh, Title 4E, things like that. So that is the biggest jump, or the biggest reason why there's a significant difference between 2018 and 2019. And then just into 2020 and 2021, as we look at our data for that 2020 and 2021, because we started an emergency background studies in April of 2020, that's really going to skew any of the data that we have, and those are just abnormal because it's not going to be apples to apples on that. But we haven't done any analysis on the 2020-2021 data, but because we weren't running fingerprint-based checks, we were only looking at Minnesota databases. You can't. It's not a simple comparison.
So may I ask a follow-up?
Sure.
Do you, Ms. Modi, do you have any sense of, like, once we get past the pandemic, if nothing changes, you know, with the statutory scheme, do you think this 2019 number would be representative of sort of a new normal? Or do we just not even, is it that too hard to
I think it's just too hard to even speculate or even think at this point. There's been so many changes just in the employment, just the workforce markets, the industries themselves. On it, I think it's too difficult to say. Just to know that, you know, we don't know what any other changes are going to come down from the Fed. There's just so much that's happened. I think it's and so many changes in the workforce market and employment market and the background studies that we do. I just don't think we're going to be able to speculate what that is. I think 2022 data will give us an idea, a better idea, but I don't think we're going to be able to really take a look at that until we get into 2023, 2024 data.
Fair enough. Thank you.
Anything else? All right. That's all I got.
Well, thank you so much, Vice Chair Evans. That's always really helpful. Charts are great. That is all that we have scheduled for today. We certainly want to open it up to any issues, questions, concerns that the task force has before we adjourn, or are people just itching to get outside? You never know. So I'll defer, be last call for questions. All right, nobody wants to be that guy. I don't blame you. With that, we're adjourned for today. Thank you all so much. Thank you from the subcommittee chairs for the presentations. I thought that was really helpful. We'll see you all soon. Have good days.
Thank you.